I'm sorry.
Oh, no, I'm sorry.
Yeah, as far as federal law is concerned, how far does with respect to motor vehicles extend? I mean, this is a classic question of causation. Does it extend to anything that could contribute to an accident?
So I'm not sure that it, sort of goes like to, the butterfly effect and all of that kind of thing. What this court has said in lots of contexts is it doesn't have to be like super direct. There's no direct link requirement, but at the same time, things that are attenuated, peripheral, and remote, I think is the phrase this court has used on a couple of occasions, are not covered. Now here, I think it's a pretty easy way to say that this is not wildly indirect for purposes.
Yeah, no, I see that, but do you think there is some limitation in this phrase with respect to?
Absolutely. But I would say, like, if I were like sitting on Congress's shoulder and saying, all right, we want direct connections only, I would say don't use the with respect to language.
And the limitation is proximate cause under state law. Is that the limitation?
Well, that's one practical limitation in this context, because you can't bring the tort against a broker under state law unless you satisfy the proximate cause requirement.
Yeah, well, I understand this is pretty direct, but if something has to be some kind of directness requirement or a minimum link requirement has to be read into C2, then I come back to the question that Justice Kavanaugh led up with, which is the real anomaly, which is very hard to accept, that there's preemption for intrastate activity but not for interstate activity. And I came to the argument hoping you were going to give us some brilliant way of reconciling these two provisions other than just live with it. But I guess there is no such theory.
If there is, it has escaped me. But as I say, I do think it's telling that you are going to have a broader intrastate preemption clause no matter how you decide this case. The other thing is, I would say, that would really be letting the tail wag the dog. I've looked through all these cases. I think there are 2 intrastate cases that I've been able to find. Maybe my friends have found more. But there are, dozens and dozens of interstate cases. And the intrastate cases I found have actually said there's no preemption on sort of the ADA. That's not what this is all about. So I think it would be a mistake to let the absence of the safety exception in B be the tail that wags the dog.